First of all, welcome to all of you from Geneva. We're excited to start again a new series of PCT webinars. 2 years ago, we focused on more advanced topics, and so we thought, now let's do a round of more basic subjects. And today is going to be particularly basic because we're at the very start. We're planning to do about seven of these episodes, and today we'll be talking about some of the fundamentals. And we called this first episode, It All Starts with an Invention. And really, that is what you need before you even consider and think about how to protect your invention and what to do with your invention. So you really need a good idea. And I have some 3 screenshots of some inventions which were eventually patented. And as you can see from these images, some look more technical and more advanced. Some look relatively simple and joyful, the little dog with the umbrella on the right, but they're all inventions. And so someone came up with these ideas and then eventually had to think about, well, what do I do with this invention? Now, some might say fame is enough for me. So if the world knows that I was the one who came up with this cool umbrella for a dog, that's all I need. And so I'm going to publish this wherever I can publish it. And that's just it. And everyone knows that it was me who came up with this. On the other hand, I mean, if you invested a lot of time and effort in coming up with your invention, then maybe just the fame isn't good enough for you, and you actually would like to somewhat commercialize your ideas and generate some revenue out of your invention. And that takes you then to the next level where you basically have to take a fundamental decision. Do I want to somehow legally protect my invention? And then you would go into the area of filing a patent application. Or maybe alternative, I would like to keep my invention secret and basically use my invention to produce a product, market and sell that product and make some revenue that way. Now, clearly trade secret doesn't work for all kinds of inventions. So if your invention is very easy to copy, to reverse engineer, so someone looks at it and is able to figure out what you have actually done, then keeping it a trade secret is not going to be possible because anyone can basically then end up copying your invention, and you can't really stop them then to manufacture the same product and sell the same product that you would like to commercialize. It's also probably more difficult to utilize the idea of a trade secret if you don't really want to work your invention yourself, if you're not the one producing the tool that you came up with and basically sell it. Because if you pass on the information to someone else, there's of course much more of a risk that the trade secret remains much less a secret in that process. And if your invention is easily copyable or easy to reverse engineer, then probably you're more likely to think of protecting it as a legal right. And there we talk then about the patent system, and the patent system around the world is the way to really obtain legal protection for an invention. Before we talk more about the patent system and patents in general, I just would like to make the remark that other than patents, there are also other forms of intellectual property. So if you are interested in protecting the name of your company, think of Adidas, Nike, and whatever you have, and Porsche, or lots of very famous trademarks, Rolex, just to come up with another one. Those are all very highly valued trademarks, and they're protected under the trademark system, either nationally or more internationally. But that's a different type of intellectual property, and it's not about protecting the inventions, but it's really the name of your company. Another type of intellectual property is designs. And so if you're more interested in protecting a certain ornamental shape of something you created, like a very cool looking new type of umbrella, just to come up with a silly example, that would be more a design application or design registration that you would go for. And this is not going to be the topic of our discussions today. So we're really going to exclusively focus on whatever we consider inventions. And I guess that begs the question, what actually is a invention? An invention, I mean, is usually defined as a technical solution or a solution to a technical problem. And for those kind of solutions, there is the possibility to obtain patent protection. And patent protection essentially is an exclusive right that allows you to commercially use your application and to exclude others from commercially using your granted patent application or eventually granted patent. If you file for patent protection, it does have a downside. If you so wish, the downside or the trade-off, if you want, that's maybe a better word to explain it, is that if you want an exclusive right, then you are obliged to publicly disclose your invention. And so if you file for patent protection, you need to draft an application which explains in detail what your invention is about, how it functions, so that others who are skilled in the art would easily understand what this invention is all about. So this is really a requirement that you need to comply with. Without that, you will not obtain a patent right for your particular invention. If you file a patent application, let's say in a national country of your choice, most likely, of course, your home country where you're located in, then that national law will usually have three main criteria that need to be fulfilled in order for a patent to be granted. And you file your applications in all likelihood with a national patent office, and it's that national patent office that will check for these three main criteria whether they're complied with or not before they then eventually decide to grant a patent to you. So the three main criteria that you need to show to the office are that what you came up with is new, so that no one else has already come up with this and published this information about this particular invention. So you're really the first one to have disclosed this invention to the public. The second criteria is called inventive step, or in some areas of the world, it's called non-obvious. So it's basically things that, even though your invention is new, it hasn't as such been disclosed. It also needs to have such a novelty step in it that it's not really obvious to someone who really understands the technology. So, I mean, a silly little example for this is we all know the pencils which have a little eraser attached to them. So let's say this idea of a pencil with an eraser hasn't really been known. But of course, before that, everyone knew what a pencil was, what an eraser was. So the inventive step really was to bring the two things together in one little product. And the question is that non-obvious enough, or could anyone have thought of this? And so this is also a hurdle that you need to pass over in order to obtain a patent. And the third criteria is usually referred to as industrial applicability, or in some countries, utility. So you need to show that whatever your invention is really can be utilized in an industrial type of process, which in some countries, at least, it would exclude certain games or similar things that don't really have an industrial applicability. But the limitations there are relatively narrow. And I think the things that are usually or most likely excluded by industrial applicability are issues like a perpetuum mobile, so a device that doesn't need any energy and continues to run endlessly. That's physically simply not possible. And as a result, it's usually turned down as it's not industrially applicable. There's also some other limitations that could still apply before you actually get a patent granted, and that is a question of whether your subject matter is actually allowed to be patentable under national or regional law. And national law at times exclude pure abstract ideas, laws of nature, or pure national phenomena. So it's not something that, you know, an individual has come up with, but something that already exists like that in nature. So that's often excluded from patentable subject matter. If you eventually get a patent granted to you, this patent right will exist for 20 years, but you will have to pay maintenance fees in order to keep it alive for 20 years. And curiously enough, most national laws have a system where you have to pay initial fees in order to file your application and then get a patent granted. Once it's granted, you have to start paying these maintenance or annual fees, and they actually get higher and higher the longer you keep the patent. So why is that? I guess the logic really is, if someone is willing to maintain a patent for 20 years, it probably means that it's a very valuable invention and that the applicant is actually generating a lot of revenue out of this invention. So paying higher fees for the 20th years is not an issue for the applicant, because the invention already has proven to be a commercial success for this particular applicant. And if it hasn't, then probably most applicants will not continue to pay these maintenance fees. Now, here's another element which is very important also when we discuss the PCT in a little more detail later on. Patent law is essentially a territorial system, and you can only expect to be granted territorial rights under the patent law of particular offices. So what does that mean? So essentially, let's say you file a patent application in the UK or in the United States or in Japan. If a patent is granted by the office in Japan, in the UK, you will only be protected in the territory for which this office is responsible. So Japanese office, it would only be in Japan that you have obtained a patent right. And that also then limits what you can do with this patent right, because basically it only allows you to exclude someone who's actually trying to use your invention in Japan. It could be that they manufacture elsewhere and try to import the product into Japan, then you can also utilize your Japanese patent rights. But let's say someone else produces the same invention after they looked at your patent application. They produce it, let's say, in another country, in China, and then they just market it in the Chinese market. In that case, you can't really do anything based on your Japanese patent law alone, because you don't have protection also in China. And so the Japanese patent doesn't extend beyond the borders of Japan, if you so wish. So this is the principle of territoriality, and that's very important and explains why only obtaining a national patent, for some applicants at least, might not be good enough if those applicants have any desire to also work their application and utilize their application and exclude others in other countries than just their home country. And so this is really the question we're now asking as a second step. So is a national patent application good enough for me? Or do I need to at least also think about whether I need patent protection in more than one country, because of this principle of territoriality that I just explained? And let's say you have a cool new invention and you think you have a market to sell this invention and the capability maybe to also to manufacture this product and sell it in other countries. Well, then maybe you would also like to explore, how can I protect this invention, not just in my home country, but also in some other countries. And if that is what you need and what you would like, well, then basically you have two choices of how to go about it. There is the traditional system that we call the system under the Paris Convention. And it's a little bit small print, but if you read the date on it, it's actually dated back to 1883. So this exists for more than 100 years, but this treaty is still alive and kicking. So it's really something you can still use today, and many applicants are still relying on this today, the so-called Paris Convention. I'll explain a little more in detail what this is all about, but let me first introduce the alternative. The alternative to the Paris Convention is the Patent Cooperation Treaty. This is the newer treaty, but if you look at the date, it was adopted in a diplomatic conference in 1970 and entered into force in 1978. It's not fresh new either, so it's been a couple of years that we had the PCT around, but in comparison, it's of course the much newer treaty. So how do these treaties work? And I think it's best explained if I show you the next slide. So the Paris Convention actually has more contracting states than the PCT. We have to give them that. So there's currently 180 contracting states in the Paris Convention. And what the Paris Convention essentially provides for, and that's why you do want to rely on the benefits of the Paris Convention in some cases, is that you can start your process of protecting your invention in one member state, and let's call this a local state, your local application where you file your initial patent application with your home patent office. And then the Paris Convention guarantees you a time frame of 12 months within which you have to decide, where else do I need patent protection? So where are my other markets that I might need protection in? Or where are my competitors that might have an interest in utilizing my invention and I want to keep them from doing it, or I want to allow them to utilize it, but then pay me royalty fees for it. So where do I need protection? And that's a decision under the Paris Convention you need to take within 12 months from your initial filing date. And before the expiration of 12 months, you need to file individual national applications in all those states where you're interested in obtaining protection. So this system is categorized by a relatively short time frame of 12 months, where you have to take a final decision as to where you would also like to obtain patent protection. But then the system guarantees you that for those additional applications that you file before the expiration of 12 months, they are treated, as far as prior art is concerned, as if they had been filed on the same date as your initial application. So what does that mean for prior art purposes? Well, it basically means that even if maybe someone discloses your particular application, maybe yourself disclosed it, after you filed your initial application, for the subsequent applications, they will still go back to the 0 time frame and still treat your application as novel and inventive, even though there was disclosure between 0 and 12 months. And this is a principle that we call the right to claim priority. So you're able to go back in time to the initial filing date, even though you only file your subsequent applications 12 months later. But this is, of course, very important protection. So you really need to make sure as an applicant to file your initial application, and then you already have some sort of protection if you make sure that you follow up with further applications within 12 months. And even if your competitor also then files an application or discloses something that is relevant to your invention, you are already protected and you can still obtain a patent before those other offices where you file your subsequent applications. So this is the traditional Paris Convention route. And let's compare that with the PCT. And one thing that's obvious, you already see, well, the timeline under the PCT seems much longer. And so what does this mean? So also under the PCT, I think about 90%, if not more, of our applicants start out with filing a first national application. And then instead of filing multiple applications at 12 months, they decide just before the expiration of 12 months, and believe me, lots of applicants wait until the very last day, even though there's no absolute need to wait so long, but most applicants do, then they decide instead of filing multiple applications, they file a PCT application. So PCT, or an international application, is a single application which then has legal effect in all the contracting states of the PCT. And we currently have 158 contracting states in the PCT. So it's fair enough that it pretty much covers the world with a few exceptions. So once you file the PCT application, you also gain additional time for having to take the final decision as to where you need protection. Why is that? Because when you file a PCT application, you basically automatically say, I want protection in all 158 states that are members to the PCT. And only at 30 months, when you have to do something that we call enter the national phase, do you really have to decide before which offices exactly do I want to enter the national phase. So this has two advantages. A, you have more time to think about whether and where you want to enter the national phase in comparison to the Paris Convention, but it also leaves you more flexibility, because maybe at 12 months, this decision is kind of tough to take and it's a bit of a rough estimate. You haven't really checked all the foreign markets. You don't really know yet how good your invention is, and maybe you still want to work a little more on some of the details. And so it can be a little bit more of a stab in the dark early on, but then with the additional months under the PCT, additional 18 months under the PCT, maybe it's a bit less of a stab in the dark. And so you also get more information during the procedure under the PCT. I'll come back to that in a moment. That will enable you to take a more educated decision as to where you really need protection and whether it's worth obtaining protection in multiple countries. So you have more time, and you also have the choice which is left open to you. You don't have to take the final decision at 12 months. And you might make a mistake at 12 months. You think I need protection in 10 countries, but 18 months later, it turns out, well, actually 5 countries are enough. And so you don't spend the effort and time that it takes to file these national applications at 12 months or under the PCT at 30 months, because you now narrow it down to 5 countries. And maybe one thing I haven't mentioned yet, obviously in all of this, there are certain cost implications. So you get a patent, so it's understandable that you also have to pay a fee to the office so that they grant a patent right ultimately to you. And also, if you file a PCT application, you also have to pay certain fees that you actually get this flexibility and this benefit of additional time. But if you look at all the fees, if you think about what's really expensive in terms of obtaining international patent protection, it's the filing of these multiple national applications under the Paris Convention or entering into the national phase. Because when you enter the national phase or you file multiple national applications, you need to pay national fees to each and every office. You need to pay for translations of your application, because most offices expect you to come with a translation into the national language. And you are probably also likely to have to hire a local patent attorney or agent to help you with the prosecution of your application with the individual national offices where you want to continue. So the bulk of the costs really come up either at 12 months under the Paris Convention or at 30 months. So that actually in itself is another advantage of the PCT, is that the bulk of the costs under the PCT come up later. So you have more time to think about, get the money together, maybe get someone to sponsor your application and your invention before you actually need to spend the money to enter the national phase. So that in itself is another advantage, but it's also an advantage in the sense, as I alluded to before, if you do change your mind between 12 and 30 months, that, if you reduce the number of countries where you want to continue in comparison to what you thought at 12 months, well, maybe then actually you're still able to save some money under the PCT. And usually these advantages clearly compensate for the additional costs involved in filing a PCT application instead of going directly with national applications. Now, I'm clearly advertising the use of the PCT, but I think it's fair to say that there are also some scenarios and some cases where I would say do consider the Paris Convention. Two things I have in mind. One is those rare cases where you need patent protection in a country that's not yet part of the PCT. And very likely it's part of at least the Paris Convention, so you have to file a direct national application. An example of this would be Argentina. So for Argentina, they're not yet a member state, sadly enough, of the PCT. There you would have to file a direct national application under the Paris Convention. So what some applicants do, they file a PCT plus a national Argentinian application at 12 months. The other scenario where I think it's worth considering the Paris Convention is if you are an applicant who's very certain as to where they would like to obtain patent protection, and you're very unlikely to ever change your mind about this. You might also only need protection in 2 countries. Then rather than, buying additional time and additional options as under the PCT, maybe you're better served just going directly to these 2 countries under the Paris Convention. But this is really dependent on your particular scenario, on your particular strategy and what your needs are. And I just at least wanted to say that don't completely just ignore the Paris Convention, just because I do tend to favor the PCT as the route to obtaining international patent protection. Basically, the idea was that we'll keep it relatively short at the outset, and then we would still open up the floor for any kind of questions that you might have on this presentation and on the topic. And if you do so, I would already invite you to use the chat function in Zoom and just type in your questions. I haven't actually opened yet the chat, whether anyone has said anything, but I'll do that in a moment. And I will then try also to answer your questions. But I hope this gave you already a little bit of an idea of what your potential options are if you have an invention, and if you decided not to keep it secret because it's just very difficult. I mean, it's not, maybe you don't have the formula to produce Coca-Cola, which is one of the famous trade secrets in the world, but it's something that's more obvious. So you need to go for patent protection. And you also realize your idea is too good to just limit it to one country. So you need protection in more than one country. And now you see the 2 options that are available to you, either under the Paris Convention or under the PCT. Now, one thing I haven't mentioned about the PCT, which I think is also another advantage of the PCT over the Paris Convention, is that in a way you're flying through the process a little less blind than under the Paris Convention. So depending on your national office, some national offices are very quick and they might already offer you a first search report on your application even before 12 months. One of the things that I haven't mentioned yet is that you're flying a bit less blind through the PCT system. And so what I mean with this is when you file a PCT application, you get at least 2 reports by one of the major patent offices that you're able to select as your international searching authority. And that international searching authority will take a look at your application and come up what we call a search report. So that's basically a report where the patent office searches all the relevant prior art, all the information that's out there and might be relevant to your application, and determines whether, these documents that they find could affect the novelty or the inventiveness of your application. And by getting such a report, you basically get an opinion from an office of the likelihood that a patent can or cannot be granted on your particular invention. So this really is super important information for an applicant. It also can be used, in terms of trying to obtain resources to fund your application from partners, because you can show the search report and show them, well, this patent office here, like the EPO, thinks that my invention is likely to be patentable. And so either the search report or the written opinion, I haven't mentioned that yet, could actually show this. It's not a binding opinion, but at least it hints and gives you ideas of what's likely to happen later on in the national phase. And as I said, it can be used as a support to obtain funding for your particular application project. But it also, of course, is a tool to simply use for you to base your decision on whether it makes sense to continue with your application and before which offices to possibly enter the national phase based on this information. So I talked about the search report. At the same time, the ISA will also issue what we call a written opinion. It's essentially a very similar report, a little more spelled out, a bit more expressly spelled out why the examiner thinks that your invention is novel and is inventive. And so it might actually be a little more accessible to those who are not so familiar with reading search reports. There are two optional procedures in the PCT. Either you can ask for a second search, which is called a supplementary search, or preliminary examination, but I think that's a topic for another time, and I don't want to get into these more detailed procedures at this stage. So right now, I don't remember what's on my next slide. This is basically a slide just showing that most applicants out there, if they want to obtain international patent protection, are now turning to the PCT rather than to the Paris Convention. They must have heard my presentation before and they're all convinced. No, I guess there are some good benefits to the PCT, and that's why we see this trend and of course are very pleased about this. Okay, before I turn to maybe some of these, some of the questions, here is a reference to our PCT resources website, which is available in 10 languages. And I might just want to use this opportunity to tell you that we have recently modified and modernized our website. If you have any comments or have a hard time finding information, please let us know. I hope it's actually easier than it was, but you never know. So please leave your comments if you have comments on that. And on the last slide, we really would like to offer our help to anyone interested in filing PCT application. We have a standard help desk, the PCT info line, that can be reached at local time Geneva between 9 and 6 o'clock at night. Email is, of course, probably the easiest way to reach us, but there's also a telephone number. So please do utilize the resources that we have on our website and also by contacting us directly to help you with any questions about the PCT, but also if you encounter any difficulties when filing PCT applications. Okay, there's a question. Is there a WIPO window where an international patent can be filed, for example, a patent application to all central banks across the world? So I don't know whether I covered this in sufficient detail, but basically what the PCT offers, and WIPO administers the PCT, so it's a WIPO product if you so want. It's an application procedure where you can file an international application and you basically buy into the option of later continuing before one of our 158 contracting states. But in order to obtain a patent through the PCT system, you still need to enter the national phase. And I might not have stressed this sufficiently before. So there's no such thing as a PCT patent. So you won't be granted a PCT or international patent. You really need to take your application to each national office or regional office at 30 months when what we call you enter the national phase. So you don't forego having to take your application to the individual offices where you're interested in, but you're just able to postpone when you have to do that and also your choice of offices to a later point in time in comparison to the Paris Convention. So I hope that answers that question. So there's nothing really specific that would allow you to somehow reach all central banks across the world. That is not something or a service that we could offer. It's basically you file your application and you need to decide where you want to enter national phase. and that would go to the national or regional patent offices, not to particular banks or something. Another question, once your patent has expired, could someone else seek patent protection for a similar invention? So once your protection has expired, now your invention is actually free for anyone to utilize, either to do further research on this invention or to actually, build a tool with that invention or based on that invention. So they're able to use it. However, they're not able, or no one is able to still file another patent application for this invention. Because, as I said, if you file a patent application, it comes with the obligation of disclosing your invention. And once your invention is publicly disclosed, anyone who files after this disclosure will be told that this is not a new invention because it was already shown to the public. So it doesn't meet the first main criteria of patentability, that is novelty, anymore. So once the patent term has expired, no one can again apply for a patent for that invention. It's different if someone, uses that invention and builds on it and maybe adds some additional elements which weren't in the patent application before, and they're so, additional that they actually merit a new patent. Then possibly there is an opportunity, but it's really only on those new elements, not on what was already disclosed before. I hope that's clear enough. Are there users who prefer only PCT over Paris system? Yeah, clearly there are some companies out there that simply decided, I don't want to every time take a decision Paris or PCT. I'm happy with the PCT, so whenever I have a good invention that I want international protection for, I will always choose the PCT system. But of course, others do fine-tune their decision, so it really is a choice of applicants out there. Okay, there's another question. If I decide to do national phase entry in the US at 30 months, when do the protections start in the US? At the 30-month or PCT filing date or at the priority date? Yes, that's a very good question, and it's of course already more detailed than I planned to be in this particular basic introduction here. But I think this is a point that doesn't only apply to the US, but to any state that you seek patent protection in when you file a PCT application. So as I said, when you file a PCT application, very likely you will have a first national application, which sets the priority date. And then 12 months later, you file your PCT, which will then automatically, what we call, designate all of our contracting states. And then at 30 months, you enter the national phase. So in terms of prior art and whether your invention is novel or is not novel, the decisive point is the priority date. So it goes all the way back to your first national application. And if nothing was disclosed that would hurt the novelty of an invention before the priority date, it is likely that you would get a patent granted in the US or in other designated states where you enter the national phase. And so, yes, arguably, you could say, some protection, some type of provisional protection, if you want, does exist from the priority date. But whether you ultimately protected, of course, depends on the decision of the national office that will decide once you enter the national phase, will they grant a patent or not? So let's say the US decides for whatever reason not to grant a patent, then of course you're not really protected at that stage anymore. And any protection also, there's no point in trying to go back because basically no patent is granted. Okay, so there's a question, and will BIS collect royalty fees, both WIPO and BIS, for fees deductible from royalty fee collected and accrued? I am not sure I know even what BIS is. So maybe you can further clarify this question. I'm not really sure what this is. I did try to describe the kind of fees involved. So, if you file a national application, you have to pay national fees to the patent office. If you if you file a PCT, you have to pay international filing fees. If you file direct other subsequent national applications, you have to pay fees to those offices. So there are all kinds of fees involved, but I'm not quite sure exactly what you're referring to. Okay, what topics will you cover coming up? Yes, we did come up with a list, and I don't unfortunately have it in front of me, but what we will do is we will just talk more about the details of the PCT system, still at a relatively basic level to make it understandable for those of you who are not so familiar with the PCT. So, what do you have to do to file an application? Where do you take your application? What kind of tools might be out there to help you file your application. Then how does the processing work doing what we call the international phase? What steps do you have to take to enter the national phase? So all of these things will be explained in more detail in later sessions. And sorry, we don't really have a time frame yet when we will do the later sessions. It's a bit kind of the summertime here in Europe, so lots of people will be on leave soon. So most likely we'll pick up with the next next episode in September. And so just keep an eye on our website where we will announce also the next session and also the topic of the next session. Okay, and I think that covers also the next question. Can I file a PCT application directly without a local application? Yes, absolutely you can. There's some big companies, for instance, Qualcomm is relatively known for doing that. They don't actually file national US applications. They start right away with a PCT application. Now, what's cited usually as a downside to filing a PCT directly is that your patent term starts to run from the filing of your PCT application. So if you're really interested about a very long patent term, then some applicants feel they're better off filing a first national application and then filing a PCT application at the end of 12 months, which will give them this additional year, if you so want, where the patent term then starts in all of those other countries other than the country where you filed your first national application in. But if patent term isn't such a big issue, maybe you're in a fast moving technology anyway, and very likely after 10 years your invention will be completely obsolete, then just simply going ahead and starting out with a PCT application direct is an absolute possibility. Applicant inventors from which countries could not file PCT applications? What their connection should be to PCT member states? Okay, so it's a good question. National applications usually do not have particular requirements in this regard. So let's think of a US application. Anyone really can file a US application, whether they're national or resident of the US. That's a bit different from the PCT. So if you want to file a PCT application, one applicant needs to be a national or, and I'm stressing or, a resident of a PCT contracting state. So that excludes someone who's, let's say, a national and resident of Argentina. So they could not at the moment file on their own, at least, a PCT application. But if someone from Argentina decides to, team up with a co-applicant from Brazil, and Brazil is a member state of the PCT, then they could go ahead and file that PCT application. So the requirement really only needs to comply with by a single applicant in the PCT application, but at least one of them needs to be a national or a resident of a PCT contracting state. So the or means, let's say you're a national of Argentina, but you reside in Brazil, then you would also be fine to file a PCT application. Good question. What are the reasons why a country like Argentina is not in the PCT? And you're probably best off asking Argentina yourself. We've had many discussions with Argentina over the years. I think there's one argument that we keep hearing from Argentina every once in a while, and that is they're a little bit worried. Some of the patent attorneys in Argentina that once a country joins the PCT, they might lose business. And I think there is some truth to that, but only in a very temporary kind of line of thinking. So, if you go back to this slide where I explained that you have more time under the PCT. So if someone files a direct national application after 12 months or before the expiration of 12 months, then, the application within 12 months from the initial filing comes to Argentina. But if the same is done under the PCT, it would mean the application only comes to Argentina 18 months later. So the patent attorney firm in Argentina will have potentially less business for 18 months until the time limit under the PCT has been fully utilized and the applicant then comes to Argentina. And for some small law firm, basically getting less business for 18 months might already be something quite negative. And so there has been opposition by the patent attorney community in Argentina against joining the PCT for that apparent reason. Another reason that we have heard is that there is generic pharmaceutical industry in Argentina that's quite strong, and they feel it might also affect their business negatively if Argentina joins the PCT. What we try to cite against that is that other countries like the US and actually Switzerland, where I'm living at the moment, they also have a very big generic pharmaceutical industry, and they're doing totally fine with the PCT. So we don't think it's a super convincing argument, but everyone has their own opinions on these things. And so we keep trying, but we haven't yet been successful, but we're still hopeful that eventually Argentina will also join the PCT. Okay, so the next question is, can the unitary patent fit? Now, into this strategy to get broader protection. Unitary patent, I assume we're talking about the European unitary patent system that's now live for a few years, but it's still relatively new. This actually fits perfectly into the PCT in the sense that when you file a PCT, you, as I said, you automatically designate all our contracting states, which are also all the member states of the EPO, but also all the member states of the EU, which have agreed to the European unitary patent system. And so basically what it means that nothing really changes during the international phase of the PCT. So you just go for the international phase of the PCT, and then before the expiration of 30 months, you need to decide where you want to continue. And you say, yes, I want protection in Europe. So you enter the regional phase, let's say before the EPO. And once the EPO patent has been granted by the EPO, it's at that stage where you need to decide, do I want to continue to have this as a unitary patent, or do I prefer to nationalize it individually in all the member states of the European Patent Convention? So it's something that really only happens once you're in the regional phase before the EPO, and so it kind of fits in nicely with the PCT system, basically giving applicants a choice later on whether they want a single European patent or they rather have individual national applications coming out of that granted European patent. It's a little bit complex because I haven't explained all the concepts behind this, but I hope that's at least a first answer to you. And next question was also, can you first file a PCT? Yes, you can do that. Some applicants could also decide to file a PCT and wait another 12 months and file another PCT and claim priority of that first PCT. All of this is possible, but much less likely. I mean, if you first file a PCT, usually that's all you do. And then at 30 months, you enter the national phase. Yes, so another question is about subject matter excluded. And one area I haven't talked about is issues of public morale. That is a reason why some national patent laws say we won't grant a patent on something that is contrary to our ordre public or our public morality standards. Yeah, But then again, I mean, I don't think there are really that many applications that are affected by this, because clearly the vast majority of the applications that we see are very technical in nature, and probably have less of a moral implication, at least not a direct one. And as I said before, it could also then be, natural phenomena that basically exist, and where a human being wasn't really involved in coming up with something new. It was basically just a discovery of something that exists in nature. Those kind of things are often also excluded from patentability. Beyond basic, but could an applicant from a PCT country be included in the PCT application and then being withdrawn after filing date has been accorded, so applicants from only one non-PCT countries will be left? Yes, very good question, and I definitely agree it's beyond basic. So the requirements under the PCT are that only at the time of filing do you need to have an applicant who qualifies to file a PCT application. And I already explained before what it takes to qualify to file a PCT. So you have to be a national or a resident of a PCT contracting state. And if that's the situation, you are entitled to file, but that is a requirement that's only checked at the international filing date. So the receiving office will grant you an international filing date after they've checked this. And then right after that, you could go ahead. So the second day or the next day after filing, you could file a 92 bis request for recording of a change and replace that applicant from a PCT country with an applicant from a non-PCT country, if you so wish. That would not destroy in any shape or form your PCT application. It would still be considered a valid PCT application, and you could continue with this application into the national phase. There's procedurally only one little issue you might need to be aware of. I didn't talk about the Chapter 2 procedure and the possibility to file a preliminary examination or a request for preliminary examination. Sorry, it's a demand for preliminary examination, to be absolutely correct. And if you were to do that, again, we would check whether the demand has been filed by someone who's a national or a resident of a PCT contracting state. And if you're really interested in filing this optional procedural step, it's better than to remove the applicant in question or replace him with an applicant from a non-contracting state after you filed your demand for international preliminary examination. But it's a niche, consideration. But otherwise, you should be fine with just one applicant remaining who is not a national or a resident of a PCT contract state. And you might be wondering why we would be so flexible about this. Essentially, you need to remember that the PCT started out in 1978 with only 18 contracting states, and to limit applicants to transfer their rights to only within these 18 contracting states would have been a considerable limitations on the freedoms of applicants. And so the member states felt, no, I mean, it has to be possible that you transfer the rights to your applications to anyone. You can sell your application to anyone, even if they're not yet a member state of the PCT. And that's why basically this has always been understood in this manner, that you only need to comply with this requirement at the time of filing at the PCT. So sorry, that was really beyond basic, but I hope it answers this question. Okay, I still have one more question. I don't know where. We're 1 minute left in our session here, so we got to end now. But this is the last question, and thanks for asking all of these questions. Could a non-human inventor be listed in a PCT published application? So yes, this is a question that has been asked and actually has been tried. So there have been applications filed, both national and a PCT application, with an indication that the invention was made by artificial intelligence. We, as far as the PCT and the International Bureau were concerned, took the approach that it shouldn't be up to the International Bureau to decide on this question. So we were willing to not challenge who was indicated as the inventor, but we accepted the indications as they were. But we left the ultimate decision to the national offices where the PCT application would enter the national phase. And it's extremely likely that most designated offices would later on then not accept a non-human inventor to be the inventor of a particular patent application. So you might get through the international phase without problems, but once you enter the national phase, this could become an issue. So I would be extremely careful if I were an applicant to maybe try something like this, or at least understand what could happen to you possibly later on in the procedure. And I think with this, we're pretty much at the end, and the time frame is out. So again, thanks so much for all of you to join this initial first episode. And I'm really looking forward to seeing, at least hearing or getting your questions also in the next episode. And as I said, please check our website for information on our next episode. And please join us again here